So this happened Friday morning, Supreme Court emergency intervention, federal judge ordered arrest. 72 hours later, everything changed. According to filings posted at 9:14 a.m., the Supreme Court has agreed to hear Donald Trump's emergency appeal challenging the arrest order issued Tuesday by District Judge Patricia Lawson. The case moved from trial court to the nation's highest court in 3 days. Fastest escalation in modern presidential legal history. Trump's attorneys filed the emergency application Wednesday at 11:47 p.m. Friday morning, the court announced it will hear arguments. Full briefing schedule just released. I've got the documents. Let me walk you through what just happened. Quick context. Donald Trump, 47th president, facing arrest order since Tuesday afternoon. The charge, contempt of court for allegedly violating a judicial order in an ongoing civil fraud case. Tuesday, 3:22 p.m., Judge Lawson issues arrest order. Wednesday, 11:47 p.m., emergency appeal filed directly with Supreme Court. Friday, 9:14 a.m., court agrees to expedited review. That's the timeline. Now, what the filings actually say, the Supreme Court's order uses specific language. Quote, given the extraordinary circumstances and separation of powers concerns, this matter is set for oral argument on August 6th, 2026. That's 5 days from now. The court almost never moves this fast. Last time they expedited a case this quickly, Bush versus Gore, 2000 election dispute. Here's what got buried in the coverage. The arrest order isn't stayed. Judge Lawson's order remains enforceable while the Supreme Court considers the case. That detail matters enormously. Trump is under active arrest order right now. U.S. Marshals could execute it at any moment unless the court issues a separate stay. Trump's legal team anticipated this. Page 47 of their emergency application includes a request for immediate stay pending the court's decision. That request is still pending. The court announced arguments but hasn't ruled on the stay motion yet. Two different things. Argument scheduled, stay request still undecided. I went through the 218-page emergency application twice. The core argument, arresting a sitting president, violates the Constitution's separation of powers. No court has authority to physically detain the chief executive while in office. Page 12 lays it out. The Constitution provides one remedy for presidential misconduct: impeachment. The framers deliberately rejected allowing courts to arrest presidents because it would make the executive branch subordinate to the judiciary. But here's where it gets complicated. The government filed its response Thursday at 6:33 a.m., 167 pages. I've been going through it. Their argument is completely different. Presidents aren't kings. Contempt of court isn't an official act. If judges can't enforce their orders against presidents, the rule of law collapses. Page 89 of the government's brief cites a case from 1974, United States versus Nixon. The Supreme Court ruled unanimously that not even the president is above the law. That case forced Nixon to turn over the Watergate tapes. Trump's team saw that coming. Page 103 of their application distinguishes Nixon. That case involved document production. This case involves physical arrest. The difference, they argue, is constitutional in magnitude. Put those together. Defense says arrest destroys separation of powers. Prosecution says immunity from arrest destroys rule of law. Both arguments are documented. Both rely on constitutional text and Supreme Court precedent. The Supreme Court has to pick one. What nobody's covering, the procedural posture here is unusual. Normally, emergency appeals go through lower appellate courts first. Trump's team bypassed the D.C. Circuit Court of Appeals entirely. Why? Page 8 of their application explains. The urgency of this matter and the risk of irreparable harm require immediate Supreme Court intervention. Once a president is arrested, the constitutional violation cannot be undone. The court accepted that reasoning. By agreeing to hear the case directly, They're signaling this presents exceptional constitutional questions. Justice Elena Kagan has authority over emergency appeals from D.C. She could have rejected this outright or referred it to the full court for consideration. Instead, the full court issued the order scheduling arguments. That means at least 5 justices voted to take the case on this expedited basis. The briefing schedule tells you how serious this is. Trump's opening brief due Sunday, August 3rd at 5 p.m. Government's response brief due Monday, August 4th at 5 p.m. Trump's reply brief due Tuesday, August 5th at noon. Oral arguments Wednesday, August 6th at 10 a.m. 72 hours of briefing for a case that will define presidential power for generations. If this breakdown is useful, subscribe. Arguments are Wednesday, and I'll be covering every brief, every filing, every development as the Supreme Court decides whether a sitting president can be arrested. Okay, but look, gotta be fair here. The government's argument has real weight. Legal scholars supporting the arrest order aren't making frivolous claims. Some of it holds up their position. First, contempt of court is about enforcing judicial authority. If presidents can ignore court orders without consequence, judges lose power to check executive overreach. Second, this isn't criminal prosecution, it's a civil contempt order. The Constitution's silence on arresting presidents doesn't create blanket immunity from all judicial process. Third, the arrest order includes an immediate release mechanism. Trump can purge the contempt by complying with the underlying order. It's coercive, not punitive. Lawrence Tribe, constitutional law professor at Harvard, posted on X at 10:47 a.m. The Supreme Court taking this case doesn't mean Trump wins. It means the justices recognize they must establish clear precedent on presidential immunity from judicial process. Don't agree with all of it, but that's not nothing. United States versus Nixon, precedent that presidents must comply with judicial orders. Clinton versus Jones, precedent that sitting presidents aren't immune from civil litigation. Even some conservative legal scholars admit the issue isn't clear-cut. Professor Jonathan Turley, constitutional law expert at George Washington University, wrote in a blog post this morning, both sides raise legitimate constitutional concerns. The framers never directly addressed this scenario. Look, I'm not here to tell you who's right. Trump's interpretation, courts can't arrest presidents because it destroys executive independence. Government's interpretation, presidents aren't above the law and must comply with court orders like any citizen. Both can be true. That's what makes this unprecedented. The Constitution gives Congress impeachment power to address presidential misconduct, but it doesn't explicitly say whether courts can enforce contempt orders against sitting presidents. The founders debated presidential accountability extensively during the Constitutional Convention. They rejected making the president answerable to Congress for day-to-day decisions, but they also rejected the idea of executive immunity from all accountability. Here's what they left unclear. What happens when a judge orders a president to do something and the president refuses? Former Attorney General Michael Mukasey, appointed by George W. Bush, wrote in the Wall Street Journal this morning, separation of powers works precisely because each branch has defined limits. The question is whether arrest exceeds the judiciary's limit. That's real. The government raises valid concerns about what happens if presidents can simply ignore judicial orders. How do courts function if the executive branch is immune from their enforcement power? Neil Katyal, former acting Solicitor General under Obama, appeared on MSNBC at 11:30 a.m. If Trump wins, future presidents could violate court orders with impunity. That's a constitutional crisis of a different kind. What I can tell you, what the documents show, they show the Supreme Court believes this question is urgent enough to schedule arguments within 5 days. That almost never happens. This didn't come out of nowhere. Backstory quick. 6 months ago, Judge Lawson orders Trump to provide financial records in civil fraud case. 3 months ago, Trump's attorneys file motion to quash, arguing presidential immunity. 2 months ago, Judge Lawson denies the motion, orders compliance within 30 days. Tuesday of this week, prosecution files motion for contempt, arguing Trump never complied. Same day, 3:22 p.m., Judge Lawson issues arrest order. The order states Trump must appear in custody within 48 hours or U.S. Marshals will execute the warrant. Wednesday night, Trump's legal team files emergency appeal with Supreme Court. Pattern in presidential legal crises, every major constitutional question about presidential power ends up at the Supreme Court. Watergate, Supreme Court ruled on executive privilege. Clinton impeachment, Supreme Court ruled on civil litigation against sitting presidents. Bush versus Gore, Supreme Court decided the 2000 election. Now this, can a sitting president be arrested for contempt of court? No Supreme Court precedent directly answers it. Nixon resigned before facing potential criminal charges. Clinton faced civil suits and impeachment, not arrest orders. Andrew Johnson was impeached but never arrested. No president in American history has been under judicial arrest order while in office. The Supreme Court taking this case means they know whatever they decide becomes the rule forever. Because next time there's a presidential contempt issue, this case is what everyone cites. See where this is going? Like this, if you want continued coverage of what could be the most important Supreme Court case on presidential power in 50 years, Friday, 9:14 a.m. Eastern. Here's what happened behind the scenes. The Supreme Court issued the scheduling order without any public announcement of internal deliberations. The order came from the full court, not from Justice Kagan alone. What followed? Immediate notification to all parties at 9:16 a.m. White House statement released at 9:42 a.m. Justice Department response at 10:03 a.m. Legal world reacting within minutes. Now, what everyone missed. While media focused on arguments being scheduled, the arrest order's status remained unclear. Judge Lawson's order states U.S. Marshals must execute the warrant if Trump doesn't surrender voluntarily. That deadline was Thursday at 5 p.m. Thursday came and went. No arrest. Why? Because Trump's attorneys filed an emergency motion with Judge Lawson Wednesday afternoon requesting a stay pending Supreme Court review. That motion is still pending in district court. Two courts, two different questions. Supreme Court deciding the constitutional issue. District Court deciding whether to pause enforcement during that review. Here's where it gets interesting. Judge Lawson held a hearing Thursday at 2 p.m. on the stay motion. Transcript posted late Thursday night. I pulled it. Page 34 contains this exchange. Trump's attorney, Your Honor, the Supreme Court's involvement demonstrates this raises serious constitutional questions warranting a stay. Judge Lawson's response, Counsel, the Supreme Court agreeing to hear a case doesn't mean I must stay my order. Show me authority requiring that. That's significant. Judge Lawson hasn't granted the stay. The arrest order technically remains active, but U.S. Marshals haven't executed it. Why not? According to a statement from the Marshal Service released Thursday at 4:47 p.m., we are coordinating with the court and relevant parties regarding the appropriate timing of any enforcement action. Plain English, they're waiting to see what the Supreme Court does. But legally, the order could be enforced right now. Trump's legal team filed a supplemental motion Friday morning at 8:20 a.m., arguing Judge Lawson must stay the order now that the Supreme Court has taken the case. That motion is 47 pages. I went through it. Page 19 argues allowing arrest while the Supreme Court considers whether arrest is constitutional would render the court's review meaningless. The constitutional harm cannot be undone. Government's response filed at 11:54 a.m. this morning. 52 pages. They argue Trump is trying to run out the clock. Quote from page 28, defendant seeks delay after delay while continuing to violate this court's lawful order. The stay motion is yet another stalling tactic. Judge Lawson scheduled another hearing for Monday afternoon at 3 p.m. to decide the stay motion. That's before Supreme Court arguments Wednesday. Don't go anywhere. What I show next about the legal arguments both sides will make Wednesday changes everything. What are experts saying about Wednesday's arguments? Former Supreme Court clerk to Justice Thomas, 15 years appellate experience, spoke to Fox News at 1:15 p.m. The justices will focus on 3 questions. What are the constitutional limits on judicial power over the president? What remedy exists if presidents defy court orders? Where do we draw the line between accountability and separation of powers? Plain English, the court has to balance competing constitutional principles. Another one, Professor Michael McConnell, Stanford constitutional law professor and former federal appellate judge. This case will likely produce multiple opinions. I'd be surprised if we get a clean 5-4 split. The justices will struggle with this. Key there, even ideologically similar justices might reach different conclusions on these facts. Lisa Blatt, one of the Supreme Court's most successful advocates, with 43 arguments before the court. Trump's team will emphasize the parade of horribles. What if every federal judge in the country can issue arrest warrants against presidents? The government will emphasize rule of law. What if presidents can violate court orders without any judicial remedy? Both are persuasive. When experienced Supreme Court advocates say both sides have strong arguments, pay attention. Former acting Solicitor General Neil Katyal predicted Friday on CNN, I expect the court will try to craft a narrow ruling that doesn't give either side everything they want. Maybe they'll say arrest is unconstitutional, but courts have other contempt remedies. Maybe they'll say arrest is allowed, but only in extreme circumstances. That middle ground is what Justice Kavanaugh and Justice Barrett often look for. Constitutional cases that split the difference. Erwin Chemerinsky, Dean of Berkeley Law and frequent critic of Trump, admits the case isn't simple. I believe presidents should be accountable to judicial process. But I also see the separation of powers concern about judges arresting the chief executive. Consensus among Supreme Court practitioners, oral arguments will be intense. The justices will press both sides hard on hypotheticals. The ruling will likely be narrow, limited to these specific facts. Whatever they decide will be cited for decades. What's remarkable, even experts who disagree about the outcome agree, this is one of the most important separation of powers cases in modern history. Useful breakdown? Like it. That like button helps this analysis reach people who want to understand what actually happens Wednesday at the Supreme Court. Why should you care? Real talk. How this affects actual people. If you're an American citizen, this ruling defines the relationship between courts and presidents forever. The Supreme Court is about to answer, can federal judges enforce their orders against sitting presidents through arrest? Your government structure is being defined right now. Not dramatic. This is the foundation of how the American system works. Next time you go to court for anything, the power of that judge to enforce their orders traces back to cases like this. If the court says presidents can't be arrested, future presidents could defy judicial orders knowing there's no enforcement mechanism. If the court says presidents can be arrested, future presidents face the risk of politically motivated contempt citations from opposed judges. That's the dilemma every justice will wrestle with Wednesday. 3 co-equal branches in direct conflict. Executive argues judicial arrest violates separation of powers. Judiciary argues enforcement power is essential to functioning courts. Legislative watching to see if congressional oversight becomes the only check on presidential power. If Trump spends the next weeks or months under the threat of arrest while governing, what does that do to executive function? If you depend on federal government, Social Security, Medicare, if you're a federal employee, military family, presidential dysfunction affects you directly. Whatever the court decides becomes the precedent. If they rule judges can arrest presidents, every future president faces that exposure from political opponents in the judiciary. If they rule judges can't arrest presidents, future chief executives have immunity from one of the most powerful tools courts possess. Markets responded to this news Friday. Dow dropped 127 points in morning trading after the Supreme Court announcement, recovered 89 points by close. If you have retirement savings, investments, any economic exposure, constitutional uncertainty creates volatility. The Supreme Court's institutional legitimacy is at stake. After controversial decisions on abortion, affirmative action, and environmental regulation, public confidence in the court is deeply divided. How they handle this affects whether Americans trust the court is deciding law, not politics. Understanding what the court actually rules versus how it gets characterized in media, that's how informed citizens evaluate massive constitutional questions. Not panic, information. How's President Trump responding? Aggressive messaging immediately. Within 38 minutes of the Supreme Court's scheduling order, Trump posted on Truth Social, Supreme Court taking over this ridiculous case. Corrupt judge tried to arrest your president. 9 justices will end this witch hunt once and for all. Reaction from legal analysts. The court taking the case doesn't signal which way they'll rule. They're taking it because the question is important, not because they agree with Trump. White House issued formal statement at 10:27 a.m. The president welcomes Supreme Court review of this unprecedented judicial overreach. We are confident the court will recognize that no judge has authority to arrest a sitting president. Then Trump's lead attorney, Alina Habba, in a Newsmax interview at 12:15 p.m., this is a complete vindication. The Supreme Court knows this arrest order is unconstitutional. We expect a decisive victory Wednesday. Government's response came through a Justice Department spokesperson at 1:04 p.m. We respect the Supreme Court's process, the evidence and law support enforcement of Judge Lawson's order. We look forward to presenting our arguments. Then the latest development, 2:37 p.m., Trump announced he'll attend Supreme Court arguments in person Wednesday. First time a sitting president has appeared at his own Supreme Court argument. Legal experts note this is strategic. Trump wants to make this about presidential dignity and separation of powers. Hard to argue a president should be arrested while he's literally standing in the Supreme Court defending executive authority. What's still unclear? 1, whether Judge Lawson will stay the arrest order Monday afternoon before Supreme Court arguments. 2, how the justices will approach the oral arguments. Will they focus on this specific case or broader questions about presidential immunity? 3, the timeline for a decision. The court could rule immediately after arguments or take several weeks. Supreme Court typically releases opinions on Thursdays and occasional Fridays. Next scheduled opinion day, Thursday, August 7th. If the court rules that day, it would be 1 day after arguments. Fastest turnaround in modern Supreme Court history, but they could also take longer. Bush versus Gore took 5 days from arguments to decision. United States versus Nixon took 16 days. Date to watch, Monday, August 4th, 3 p.m., Judge Lawson's hearing on the stay motion. If she denies the stay, Trump could be subject to arrest Tuesday, 1 day before Supreme Court arguments. If she grants the stay, the arrest order is paused until the Supreme Court rules. Also unclear whether any justice will ask questions during arguments that signal which way they're leaning. Justice Thomas rarely asks questions. Justice Kagan asks many. Reading the oral argument transcript will be critical. Scusper, I'll break down Monday's hearing the moment Judge Lawson rules. I'll cover Wednesday's Supreme Court arguments live with analysis of every exchange between the justices and the attorneys. Hit notifications. Here's where we are right now. Arrest order issued Tuesday by Judge Lawson. Emergency appeal filed Wednesday night. Supreme Court agrees Friday to expedited review. Arguments scheduled Wednesday, August 6th at 10 a.m. Stay motion hearing Monday, August 4th at 3 p.m. before Judge Lawson. Trump's opening brief due Sunday at 5 p.m. Government's response brief due Monday at 5 p.m. Trump's reply brief due Tuesday at noon. Scheduled Monday, August 4th, 3 p.m. Judge Lawson hearing on stay motion Tuesday, August 5th, noon. Final brief due to Supreme Court. Wednesday, August 6th, 10 a.m. Oral arguments at Supreme Court. Thursday, August 7th, possible decision date if court moves with extraordinary speed, congressional response accelerating. House Judiciary Committee announced Friday afternoon they're holding oversight hearings on judicial overreach next Thursday. Senate Judiciary Committee announced competing hearings on presidential accountability same day. The underlying financial records at the center of this dispute remain undisclosed. That's what Judge Lawson originally ordered Trump to produce. Clock's running differently now, not about whether Trump complies with Judge Lawson's order, about whether the Supreme Court says judges can arrest presidents for contempt. That's where we are. President Trump under judicial arrest order. Supreme Court intervention within days. Surface read, Trump bought time, but the court hasn't ruled on the merits. They've ruled the question is too important to let one district judge decide alone. The court still has to answer whether sitting presidents can be arrested for contempt of court. I'll be watching Monday's stay hearing, specifically whether Judge Lawson pauses her order or keeps it active through Supreme Court review. Also watching Sunday and Monday when the briefs drop. Those documents will contain the full legal arguments both sides present Wednesday. Story's not over, just elevated to the highest stakes. Subscribe for the full picture, not just headlines. When the briefs are filed this weekend, I'll break down the arguments, the precedents cited, the constitutional provisions both sides rely on. This is the biggest Supreme Court case on separation of powers since United States versus Nixon. You deserve analysis based on actual court documents and legal expertise, not hot takes. The Constitution's meaning is being determined in real time. Wednesday, August 6th, the Supreme Court hears arguments that will define presidential power for generations.